One more minute and then we'll go live. You can keep typing your questions regarding tort. If anybody has any specific questions, you can keep typing in the chat box. You can directly message to me as well. This idea of this class is to be able to, give you tools to succeed in the law of torts. Welcome, Sarah. You need to mute yourself. Very nice. So we are getting very, very good, interesting questions. So I believe we shall begin. So since we are recording this session on request of students, and I hope to provide it on my YouTube channel as well. So with your permission, I would start recording this session, number 1. So please keep sending your questions. I would keep answering your questions. Can I? So anybody would like to volunteer to be a host in this meeting so that you can admit students as we go along? Anybody would like to take the responsibility of be the host so that I can start talking and I won't be distracted?
I can do it.
Okay. And I need you to be
Answering questions too. Okay.
Yes, I need you to be a focus.
Okay.
Yeah. So how about Priyanka? Yes. Priyanka, Kalyan, Elizabeth, Maureen, anybody would like to take the responsibility? It's an honor. You are host. You can even kick me out from the meeting. Girl, you're not teaching properly. Hello, Sarah. Are you there?
Hi. Yeah, I can do it if you want.
Yes, I am going to make you host in this meeting so that you can adding students in now. So we are recording this session. Welcome to Canadian Law Tutor. I'm Virk, lawyer from Ontario, Canada. I teach NCA courses as well as bar exams. I enjoy teaching. It's my passion because I believe that law can be taught in the less painful and less foggy way. I was in your position in 2009 and 2010 when I was writing my NCAs. I understand your challenges, and I hope to provide you all the tools to succeed as a Canadian lawyer in Canada. I understand torts is a very, very challenging subject. It's hard to control, I would say, because it's elusive, it's deceptive. So we are privileged to have Heena Kapoor over here. She is Canadian Law Tutor Alumni. She passed torts. She's a wonderful lawyer. She's currently an articling student in Ontario with personal injury law firm. She herself is almost a lawyer, and she is very, very kind an intelligent person. I requested her to be able, join me in this meeting so that we can motivate and show you that it's kind of doable process and give her tools. So welcome, Heena. Thank you very much for sharing your busy Sunday, precious morning with us.
Oh, thank you. That's not a problem at all.
Yeah, so we will be taking questions because recently students have faced this challenge of lacking nuance in the answering questions in tort. So we would try to give them a strategy to succeed so that they can develop a legal argument based on principles of tort. So would you like to talk about something from your own experience about tort, Heena?
So I wrote the tort exam 3 times and I passed it on the 3rd. I think the one challenging thing was that you would know the concept, you would understand it. It's just the way of answering questions was a little different. So when I wrote it for the 3rd time, I know me and Gul talked about it and we discussed that trying to put in every option. I know there's a lot of different options that can come along with a tort claim. It's more so you learn it a lot in practice as well, but with theory, a lot of it is that you should put down every single option, any type of answer that you can possibly have so that you have more variety. I think that's what they were looking for, and that's what I lacked in the first 2 tries that I did.
Right. And would you thank you very much, Heena. That was such a, raw, vulnerable, and, wonderful event because we all need the reality and, real stories in torts. Even in life, we need real people, real stories, and real information which can motivate us. So, Heena, would you like to, talk about a little bit more about your experience, how, law of tort was kind of elusive before we met? Remember, you will be like, oh, Gul, yes, this is what, I never thought it can be played like this. So how far you would say your understanding of different questions and different scenarios played in your understanding of the exam question? So I would repeat and rephrase my question. So when you were studying, when you finally, kind of having those aha moments, understanding like this finer points can go because of, for example, difference between negligence and nuisance, we spent a lot of time on that.
Yeah.
So in that scenario, we would be, going into the understanding of 2 different scenarios, like how your understanding finally motivate your better answers in the questions.
I think when you're reading the material, there's a difference than when you try to understand it. So when I read the materials the first few times, I felt like I understood it, but then when I would write the exam, it just wasn't clear. So for me, a lot of it was also talking through each and every point. A lot of it was, I know we went through a lot where we came up with real life examples. Like we came up with the little things that you see every day in your house, in your neighborhood, and at work that would relate back to a tort claim. I know, I think one of the examples we used was parking on the street and multiple cars parking multiple times during the day, and that would become a nuisance. And I think those little examples and just trying to think of how these different concepts come up every day in your life, that made me understand it more because you can relate back to something and see how it's connected.
Right. Thank you very much. So I have now we will start taking the questions from the students. So how do we need case law and rules in application both? Okay. Rules is basically legal principles which are being triggered. For example, in tort, we can have common law principles as well. Sometimes you're dealing with a statutory law because, as a lawyer, negligence would have its own standard, its own rules and of the professional conduct. So conduct of a person when it is coming from, for example, negligence is different in all the scenarios. So rules, you don't have to put rules case laws in the rules. I believe that was the question. In my understanding, we have all the students who are, writing the exam, and they can give more. I personally have never written taught. I have only taught throughout the NCA process, and I have amazing success in teaching, because I believe understanding of concept is a very, very big thing. You need to know in your head very clearly how a taught situation can play in one or two or even three ways. So the next thing we have over here is writing the cases. First thing which I believe in the exam, which many students try to bypass because they focus. Oh, hi, we have a wonderful giggly baby in the class. Baby, we are not committing any tort by taking your parents' time on Sunday. Thank you for enlightening my day. I would love to meet you after the class. So we are talking about the how to quote case laws. So the first thing which we kind of skip in the exam is not structuring the answer. So how do we structure the answer? Especially with online exam, many students feel overwhelmed in the process, and they kind of don't know how to navigate in the screen process. So which I believe, I worked with Sarah as she's my student, and we work for her constitution and criminal law exam, and we are working on torts now. So I recommended her to use a single sheet of paper which you can tear after the exam. So write down all the issues, which while you're reading the question, don't worry about flipping the pages and all that stuff. You have read taught enough. You can identify taught. So I would say first 5 to 10 minutes navigating through the question, the scenario, spend your time and energy to analyze the answer question. Identify the issue. See, Mr. A went outside his house, he did this, he did this. So identify the issues. The examiners are, I believe, looking for your understanding and demonstration of your understanding. So the biggest mistake we make is we kind of do lots of calculations in our head, and you're like, this is not there, this is not there. No, whatever you're thinking, why something is a tortious conduct, why something triggers tortious liability, or why something is not a tortious liability, I would like to see as your examiner on the piece of paper. So the first thing you need to do is, when you look at a question, spend at least 5 to 10 minutes scribbling on a piece of paper all the issues, and the issues are your guidelines. Issues are your grand norm in the process. This is what you need to go through the answer. So I would say in any subject, including tort, is like just too much stuff, because one conduct can go trigger one way or the other. Now, first of all, frame your issues. Write on a piece of paper, scribble issue number 1. Goal: decided to do in-person sessions during COVID. So it is a conduct. So goals conduct to conduct, have a class, in-person class at her home on Sunday morning is also a negligent conduct and nuisance as well. So how goals conduct to do the same class in person, in supposing if I'm living in Toronto, because there is lockdown, there's restrictions and all that, how on gatherings and stuff. So my city says I should not have more than 5 people in my class. Sorry, at any indoor gathering, more than 5 persons are not allowed. But I advertise, make money, and get 25 students in my class at my home. So what is this? So there is a level of conduct which is negligent. Goal was grossly negligent towards the rules of, because gold never did this is not crime, it's a civil liability. So you have to switch gear how you think. So you have to claim, goal may be, criminally liable under the criminal law, but we are in the tort situation. So you have to, kind of focus your thinking from the tort angle. So goal is negligent in her conduct by inviting this, and despite, going through the pandemic, she continued to do in-person classes and things like that. So that is goal's conduct coming from negligent. Now, goal is causing nuisance as well. New goal is making a neighborhood unlivable by inviting so many students over there, and there are cars in the parking areas. And now the next thing goal is doing is, due to COVID, she's increasing the risk now of COVID. So you will frame that in your issues. The first thing is you have to find how goal is liable in these 4 or 5 situations you believe. Plus, there can be Heena in that example who was doing an advertisement. She was bringing food and she was like overlooking, or she is a city, I would say, city administrator who was giving permission to Gul to do this despite pandemic. So you have to find how Heena is liable in this situation, right? So make sure you, in the first time in the question, the first thing we need to know is spend enough time with the issues. So the number one thing is identify the as many issues you can. So that's our number one priority in the exam. Identify as many as issues you can in a situation, frame them on a piece of paper before you start typing. I know it's a double kind of somebody who has less typing speed or something, it can be quite cumbersome. Plus, but this is how a lawyer thinks, because we always scribble things on paper, write it, and then kind of apply our mind. That's how our brain is normally function in the process. I've seen students who are writing their issues before jumping into an online exam start typing, they perform better because they kind of wrap their head around what's going on. So the first thing we are doing over here is make sure you, in the first situation, make sure you identify the issues. Now that is your issues, that's your guideline, and you can keep referring to that. Now, rules is simple. Your any major case law, any principle, any liability issue, or any provision statutory, if they have given you a hypothetical situation, for example, city's bylaw and goal is violating that because of even in the pandemic. So you can have that kind of thing in the rules as well. Now coming to the application, which is the mystery box in tort exam for the students at the current situation. Refer to issue number 1. So you can actually write very simply in the exam that let's talk about Go's liability first, and then we will move on to Heena's liability. Now, when you're talking about Go's liability in the exam situation, you will go with number 1, all the case law related to that. So issue number 1, these are the 2 cases which lay down the rules. You don't have to quote the whole case. You can say Cook versus as laid down by this, as Honorable Supreme Court laid down this. So that's how you relate. And now you don't quote that principle right away. You don't have to. Examiner knows that it's an open book exam and that you have all the information in your exam. So how you quote a case law, you relate the case law. So Go's conduct is equal to this, and this has already been established standard by Cook versus Lewis case, and that case, and then you relate to that, and we go into the basic understanding of the case at that level. So that's how you go through the application process. Application process simply means applying the cases, applying the settled law in our country, recognize established law in our country, and relating, analyzing, applying on that particular issue. So you have to say Heena's liability on A, B, and C, how it goes into this picture at this level. Yes, so next question we have is, Yes, so the next question we have from the student is duty of care. It is important that we know all established categories of duty of care. Is it even possible to know all of them? So Henna, would you like to say something from the student's perspective? You have recently been through this pain. How would you describe duty of care in this situation?
With duty of care, I found with the questions, you kind of just go through it. Once you have an understanding of what a duty of care is, just going through the steps to see how that duty is affected. I know there's a lot, and I know that there's a lot of standards of the duty of care. There's a lot that you can actually see, but what I did, I think I had a chart where I had everything kind of just laid out so that I knew what the steps were in the duty of care, but then I also knew, like I made little point form notes. So I had a little bit of a summary for all of it.
Yes, so next question we have is, do we need to have no, the first thing you need to describe is what is duty of care in general. So what does duty of care means in the tort liability? So Gul may be more liable being a lawyer. She understands the rules. She is, she knows that her neighborhood has old people. So she understands that she lives in a high risk society and the facts and stuff, high risk area and stuff. So we are going back to the same example of tort. When I invited people to come to my house to do, attend my tutoring sessions for torts, and we are trying to analyze this. So the first thing in the duty of care is we need to discuss what the duty of care in general is, and then you don't have to go for every element of duty of care. You have to say which one is applicable over here and why. As your law tutor, from a teacher's perspective, so there are two things. One is the legal. So you have to understand what is overall understanding of NCA exam is. Overall understanding of NCA exam is, as an articling student, are you able to demonstrate all the legal scenarios in the picture or not? So NCA exam, which I believe is not to, it's not a lawyer competency exam. You don't have to make a perfect decision in the situation. You have to explore all the possible legal scenarios and argue why scenario number one is more efficient, more effective than scenario number two. That's my understanding, and what I, if I'm your examiner, that is what I would be looking as from you as a law student. So next thing we are trying to go over, I believe I have answered the duty of care question. If you still have the question, I would love to, talk about this. In the case law, should we be only the facts we get or journalize case law? So I would say in the case law, you need to understand why particular principle is more relevant than, so why a particular principle is more relevant at this level, how it relate to the fact at this over, and what is your analysis of that. That's your key. That opportunity is to demonstrate you understand tort law, you can apply tort law. So Henna, would you like to say something over here?
Yeah, so applying the cases with the principles and with the theory, I think, I don't remember the exact question that I had, but they were asking for the liability on different people. And so I kind of went through that, and then I would take a case that I remembered and I would put it into that scenario as having related back to either whether it was duty of care and establishing that to see which case fits best establishing the duty of care, and whether they have a higher standard or the standard of a reasonable person. If it was higher, you would take a case that you like, let's say, I don't remember if there was a doctor or pharmacy involved. There's something where I remember putting in a case where I had to establish that someone's duty or standard of care was higher, or they were at a higher standard of care than the reasonable person. So I added that in, and how I just did that was I would put so-and-so case established the standard of care to be this, and the situation is similar to this person's scenario. So as long as you can put, I feel like it's better to have cases that fit better into the facts of the scenario, but for just describing the general theory and describing the general concepts, maybe the general case law would be best.
So there is a specific question for you, Heena, that how do you believe your answering changed in the third attempt when you wrote the third time, like how it changed and how did you, differentiate, wrote it better than, your first times? What do you feel as a different, apart from that we discussed and we talked about, teaching, like how did you perform differently in the exam, which made it successful?
Yeah, I think the first two times I went through a little scrambled than I was the third time. The third time when I wrote it, I had a plan. So I know we talked about this where to like write things down and to make notes on the side. So I started doing that. I did highlight, like I highlight a lot of the important concepts in the fact scenario as well. But I think I was just more mindful the third time, highlight what I was highlighting and who it belonged to. So what I did was I took 2 or 3 highlighters of different colors, and then I remember the fact scenario I had was, it was about 3/4 of a page. So I went through for each person's liability, kind of highlighted what their bits were, so that when I went back to write about each person, I would know where I was looking. And it would just be easier to find instead of going back through the whole thing to look at whose situation belonged to which person and how the liability was affected. So I remember, I think there was 3 different people that I had to do liability. So I started structuring it and I focused on one, then went to the next, and then went to the other one. Whereas with the others, with the other 2 exams I wrote, I don't think it was as structured and as focused. As in, I wasn't, I would add in the one person, then I would jump to the next person, and then I would have to go back and add in more information for the first person.
Thank you, Heena. So there's another question for you. Do we mention case laws in favor and defense of the issues both?
In the exam, I can't remember what I did now.
Yeah, so I believe from the general understanding, I can give this answer that, of course, I would believe, so you have to weigh, Angad, and this is a very good question. And I believe when you are analyzing how much weightage you should be giving on defenses, if you have a, say, 20 marks question about advice goal, what are her defenses in this situation to go over, to protect her from the torts liability? Is there anything she can do to defend this action? So I would believe in that situation, if it's a 20 marks question, just to advise goal on her tortious liability defense, then you must talk about all the various options. You will say goal can use this defense, but the other party may come up with this. So this may not work. So when, as an examiner, I'm looking for your understanding of torts liability, I would like to know whether you understand that this defense may not be fully applicable in this case. So if you believe, standard of care, or, go try to talk about necessity or any other defense or anything. So you have to, or, statutory authority or something like that. So in that situation, you should always, I believe, that's my belief as a law, teacher and a lawyer, which I believe, if you are working even in my firm with me, and you are saying, goal, these are the, tortious, defenses in this situation, I would like to know why a particular defense will not be applicable in a situation. So I would like to know why it is not applicable. So if something is slightly, ruled out, or something is completely ruled out, I would like to see that in your paper. So I would say, if you have to weigh, if defense is only worth 5 marks in a situation, because this is just one of the options you're doing, then you should go for putting the defense along with your other argument. But if you're only focusing on defense is a major component, then I would like to see as a your teacher why a defense is not applicable in a situation. So of course, in against that, so I would say that would go against the defense, and I would like to see case law and your analysis both on your in your answer at that level. So any other question? Let me slowly go over the question. Yes, I would say you should, how about, so the general consensus we have this in situation that everybody is basically looking forward to have perfect answer. First, as a law tutor, I always say, as a teacher, I always say, work on your concept, have that thing clarified in your head, that why Gul is wearing pink and why this pink is not red as on her license, the seal on her license. So there is difference between red and pink over here. So as a law student, this is first thing we need to understand, is because we play with the facts, we play with the stories, we it's not like reading in law school and explaining, because from where I came, my exam process was more like, something, now they would ask you direct question, like, here is the picture of this session and this is what she is wearing, argue legally why it is pink and why this pink doesn't go with the red. So then that was my play area, I can just play the way I want. But when I came here, things changed. They put you on the NCA process is different. IRAC is a very different way of putting the answer. So they put you on the front line. You are a frontline worker. You are making the decision every day basis why this something is happening this way over that way. So there are many situations where you need to analyze it. So first thing we need to invest enough time in the tort is make sure you work with somebody, you work on your own, take help, try to understand why something is going into one liability. So that liability of a person, liability of a other person, or whether something is tortious has actually happened in that situation or not. The clarity of a concept is a very, very big thing. Now, the next thing about this is, once you are, so in open book exam, I always say, somebody told me that when I was doing my NCA process, I was working with a group and they were like, and open book exam also somewhere means don't open the book. So it means you should have so much comfort level in your head that you use the open book scenario, all the cases and everything to play. It's your playing field. You know which sheet to put and pull, and which sheet you would use to argue the case. As your examiner in an open book exam, I am looking for analysis comes from your understanding. It's the byproduct of your understanding. This is not something you can frame in all the situations. So I believe the biggest thing we're trying to see mistake as because we don't have enough information, so we believe like only these 4 or 5 things are happening, so I would use and argue that. No, there is no perfection of pre-framing of an answer. I would say read it, understand it, invest your time and energy, tab your material, and then you are the front line worker in your exam, and you make decision at that moment as your coach in the NCA process, as your tutor in the NCA process. It's my job to make you comfortable with all the concept, to train you to think from all the angles and prepare you to make all those decisions then and there at that level, and so that you You don't need me at that level to, give you a sheet and say, Goal, this is what a Goal is saying this and that I shouldn't do that. No, Goal is not reading the answer. Goal is not giving the answer. You are the one who's giving the answer. So you need to trust on yourself. You need to trust on your legal judgment at that level. You need to make, decision based on the facts. So as I go back to the first thing I said before, in the beginning of the session, that we need to put everything on a piece of paper. So everything should be on a piece of paper in an issue format, so that you have everything over there. You see, don't worry about the sheet or in any other thing at that level. Find out the faults in that person's liability in the exam question and then relate it to it. And if you don't have a specific case to do about that, and if you don't have a specific case to argue at that level, you can trust your judgment, you can trust yourself at that level and say in the question that based on these facts, this is what I believe. So you can always use the generalized case laws to help you to frame your answer. So I hope I have answered that one particular question. Yes, it's a very interesting case on negligence. Okay, so the question on the negligence is, so Angad, it's not about winning and losing. So the question is, there are many cases for negligence in which a plaintiff won a case and another in which a negligence they lost, and they were negligent. So Angad, I believe this is a very good question. You're contributing for everyone, I believe, and I'm, this is. You are pulling the class together and making it more fruitful. So I would say I go back to the same thing in negligence. First of all, as we have to see, if you're say for example you're using 6 cases, what one case basically means, what makes, so your conduct is, your understanding of a case law should not be focused on the fact why a won or why a lost in this case. Your understanding what should be why a particular conduct was found negligent and why in another case slightly different conduct. So there would not be the same facts or the same liability. It cannot be legally possible that the person has situation is there are XYZ facts and case number A, those XYZ facts are negligent, and another case they are not negligent. So there has to be slightly difference in that. So as a law student, it's your job to understand why in a particular case a person was found to be negligent and in another case the person was not found to be negligent. Now that is the key to remember, that is the key to transfer your knowledge in the exam. So when you see, you argue, I have read that case, and in that case, the similar conduct was found. The principle, this particular conduct would not be held negligent as the case laid down by this. So that's how you will talk about that. So next thing we have is about causation. Yes, causation is it's more about a subjective class. When we are talking about more in detail and in depth in a class, I would say that would go beyond the scope of framing it in next 10 minutes. If you have any other question, please go ahead and ask and type. So I have a private message. How do I what is the question? Yes. So the question is regarding conclusion. So conclusion in an answer is your own opinion. Conclusion need not to be perfect, but I would like to see as your examiner why you concluded that this particular conduct was not negligence, why this was not nuisance, why this was not some other tort or trespass or anything. So in conclusion is a very, very important part. That is one way to demonstrate your legal understanding of the concept, and I would Look, as a tutor, as your examiner, as a lawyer, mentoring you, I would like to see why did you reach the conclusion. Don't just put the conclusion, this person is not negligent. Conclusion is your another opportunity to prove that you have read and understood this subject well. So this is what you need to do at that level. Yes, conclusion is your another way to do things in more detail. So you could argue that at that level. So I would like to see detailed conclusion at that level. Yes. So somebody asked me, Anne's Cooper test should be applied in a private message or not? Yes, Anne's Cooper test should be mentioned in all the scenarios if it is applicable, and if it is not applicable, then why? So whatever you are doing, you should not in a tortious life tort, especially in the case of tort or even in any other NCA exam. I believe that there is no need for go through the perfection in the answer. The perfection should be demonstrated in your understanding and your analysis aspect. You should be able to differentiate clearly between the issues which you have already framed, why A and B are not happening at this level. That is what means by nuance in the case, because everybody need to demonstrate why A and B scenarios are not working in this case. That is what new legal argument means. It means you have to have your own innovative legal argument. It means you have to demonstrate in those connecting the dots. So the issue is more like, finding the dots in the picture, and analysis is more like you're connecting the dots in the picture. So these are all questions from the students, and I believe I have answered those. And if you still have any question, then what would you do? Yes, if duty is already established, then you can say that there is no need to do this any further analysis, and it has already been self-explanatory. It is done over there. So the question we have received is, if the duty is already given, established in a scenario, yes, then remind me that I am skipping this analysis over here. So whenever duty is already established, you need to go over the duty, and sorry, when then you go to the duty and then you rule out there is no need to establish or apply any test to apply this. Why? Because it's self-explanatory in the situation. So that I believe, as an examiner, I would like to see whether you have considered that point or not. So Hina, would you like to say something as a general advice how to prepare for tort?
I think the main thing that I learned from writing the tort exam, the amount of times I did, was if you have a clear, even if there's a concept that you don't understand, if you know where it is and you know that you have a clear understanding as how to structure your exam, and how, like with regards to what examiners are looking for, I think with the two feedbacks I got, a lot of it was you could have added this point in, you could have added this point in, you could have added this point in. And I remember that we had this discussion in our first few sessions where it was, you have to look through each possible tort that it could be. So there could be a case where there's nuisance and negligence. It could be public or private nuisance. So I think like putting both of the concepts in and describing how both of them apply. And then even at the end, if you're doing negligence, if you're doing a duty of care scenario, even if there isn't a duty of care, I still started walking through each step, just listing that it wasn't there. Just so the examiner is clear that you understand what the concepts are and you understand that you cannot move forward with this because it's something that's not working. It's not something that you will succeed in. There's no liability to be established there.
Right. Thank you very much, Hina. That's a very raw point, and this is what we all need to hear at this moment, that it's doable process.
Oh yeah.
So let me go with the questions. Yes, I believe we have covered the questions, all of those. So in the final points, if you have any, would like to add from your this session, you learned something new in this session, or you would, contribute something for to the others, please go ahead and unmute yourself and say whatever you feel like saying in this session. You can directly ask me question, ask Hina a question, or give your feedback, or how would you, like to sum up. And I would love.
Hello, ma'am. This is Manira. Good
Hi,
morning, ma'am.
Manira.
Thanks for giving your valuable time to us. We really appreciate it.
It's my
And
pleasure.
thank you for your effort. I just want to know what kind of tutoring you're providing for TORTS, because it's just the exam is on 19th.
Yes, I
So,
provide
yeah.
exam workshop. At the current moment, I'm doing exam workshop and condensed course for taught.
Okay, so the exam workshop is for one day, or it will
No,
go?
it would be split into 2 days. I believe it's always brutal to consider something to concise in one day, because it's
Okay.
lots to consume. I can, as a tutor, come and say things, right? But are you absorbing it? Are you, kind of doing it? So I'm doing a condensed course as well as, exam workshop and split. Like it's a few-day process. I don't have my details on this. It should be in my planner, and I would put in the group. Are you part of my tour
Okay.
group?
Yes, I am.
Okay.
And it would be really helpful if you put all the details about how to book the sessions and all
Yes,
those
I have
things.
few meetings,
Thank
and
you.
after the meetings, I'm going to put it in the group.
Thank you, ma'am. Thank you.
Yeah, my pleasure. Anybody else has any other input or question, so that we can wind up the session? And we really thank you very much, Hina. It's after I think we spoke after 1 year, and she did it in last January.
Yeah.
Yeah, and I messaged her. I said, Hina, I'm planning this. Would you come up, and we'll be able to spend your Sunday morning with me? And I think this is what I've earned in my years of tutoring, and this is wonderful, and it's my pleasure. And I believe you have given valuable input, and the best part is you were giving them a hope, which we all need in this, I think, in the middle of pandemic, to believe that it's doable. We need a ray of hope. We need guidance, and we need to have somebody who is so raw and who is so open to the vulnerability, and being a lawyer, and saying like, yes, I stumbled, that's how I succeed, and that's how we can succeed.
Yeah, it is. It's a very doable process. I know, like the first time I failed, and then the second time when I failed, it did hit me, but you get through it at the end of the day. You get through the whole process, and you will get to your goal. Some people sooner, some people later, but eventually you will get there. So don't lose hope. And I want to wish everyone that's writing best of luck with the exam.
Thank you. Thank you very much. So I hope if you have anything, you can always, we are part of group, and if we are not part of a group, you can message me directly on Facebook, on Skype, Zoom, YouTube, everywhere. My platform is Canadian Law Tutor, and my phone number is 647-530-4220. Please message me with more questions, and so that I can keep motivating everyone and engaging in this legal world. We need to support everyone in this situation, because I believe one thing we learned from this terrible last 1 year for the whole world is we feel isolated. So my basic intention is to make you feel empowered and make you feel connected in this process, because isolation can cause unnecessary burden in this process. And we wish you good luck, and thank you very much for giving me this opportunity to be with you. So If you enjoyed the session, you are welcome to join my classes. I teach all NCA courses as well as bar exam courses on the platform called Canadian Law Tutor. So this is your host. Thank you very much. I wish you good luck and hope to see you in the next few sessions, in the classes, and make sure when you succeed, tell me, give me a call and say, Gul, I've succeeded and I learned something in your session. That would be a valuable feedback for me. Thank you very much.